trickle in if there's anyone else. So, good afternoon. My name is Frank Valdez. I'm the Regional Director in the state of Florida for Get Quorum, an electronic voting provider. I've been in this role a little bit over 3 years and been in the industry for a number of years now. So can't thank you enough. I am actually located in Florida myself and manage the Florida markets, again, for Get Quorum. Thank you for joining us in today's webinar, a Community Roundtable, Technology and Community Governance. I think you're going to have a ton of great takeaways. I can tell you that there's certainly a superstar panel of experts here, and I will begin some of the introductions. Some of those include from K. Bender Rembaum, right? We've got Kirsten Henza, KBR Legal. She's our resident legal expert. I will let her do her intro, and then she'll hand it over to Diane Skinner, and we'll jump right into the presentation. So again, thank you for your patience, and thank you for joining us. Take it away, Kirsten, on your intro.
Hello, everyone, and thanks, Frank, for that brief introduction. Again, my name is Kirsten Henza, and I'm one of the attorneys with the law firm of K. Bender Rembaum. I'm a partner and actually manage the West Coast office for the firm. For those of you who are not familiar, we do have multiple locations throughout the state. Our main office is in Pompano Beach, Florida, but we also have an office in Palm Beach Gardens, in the Orlando area. And again, I manage the West Coast office, which is located here in Tampa. The firm specializes in community association law. So this is all we do 24/7. I've been practicing law 16 years, and I've been with the firm since 2010. And with that said, Diane.
Hello, thanks for joining us, everyone. My name is Diane Skinner. I work for Artemis Lifestyles. Our main office is in Kissimmee, Florida, near the Orlando area. I am lucky enough to be located in the Tampa area, and so I am the Director of Management Services for Artemis Lifestyles in the Tampa market. I also handle all of West Coast at this point. So we are a full service management company. So we manage HOAs, condos, all really in the state of Florida. We just opened an office in Jacksonville, and so we're growing and expanding over on the East Coast of Florida as well. So we're really excited to to have some additional business, and we're happy to be here today to talk about records. So I'll move right into it. Official records. So you may have noticed that the state of Florida is very concerned about records, and so they are passing some new laws and adding to the statutes, some requirements that we all need to follow and pay attention to. They've also added some new penalties for not listening to the requirements of the state. The condominium law has been in place for some time, and now they've kind of bridged over into the HOA, and so now some of the laws are mirroring each other. So you'll notice that I feel like in the future that may be a trend, where they're trying to make the condo statute a little more like, or the HOA statute a little more like the condo statute. So official records, what are official records? Well, I can tell you that any information produced while operating the association is considered a record and must be kept according to the required statutory time frame. Now, the time frame for most official records is 7 years at this point. So you want to make sure that your management company maintains your association records. Most records now are digital, new records, but you may have some records from the past that maybe are not digital, but they still need to be maintained in either form. We recommend that also for records that board members use a generic email while serving on the board, because emails can be used if there's a court case or something that they may subpoena an email, and also for transition. So when a new board member takes over, they could have that same email and they don't lose information that way. The board of directors should also adopt a records retention policy that is per the new law for HOAs. So your board may consult with your management company or your legal team to come up with a good comprehensive record inspection policy. You can also put things in that policy that are more specific to records requests, and that will help the management company, that will help the board, that will help the owner understand the process. We recommend a hard copy mail request, which an email request sometimes could get lost if they send it to the wrong manager. Maybe your manager changed, maybe your board members change, and so therefore the records request may not get to the right person. So you want to make sure that you have a records retention and a records request policy in place for those purposes. Also, by the end of 2024, HOAs with 100 or more lots are now required to have official records on a website of some type that owners may access. So you'll want to make sure if you don't have that in place, that you work to get that. A lot of management companies already have something in place, and more and more, I guess you could call them websites or portals, are available to homeowners now through the management company. So you can store those records right on there, make it really simple and easy for homeowners to get to most of those records. Also a requirement of the HOA statute before October 1st was to make all of your rules and covenants available to all of your current owners, and also as things change, to update that to all current owners, and also anyone moving in should also have a copy of those covenants and rules. So that's also a requirement. I mean, it's always good practice, of course, as well. But now the state is telling us as management companies and board of directors that we must comply with these requirements. Also, by January 1st, this is important if you hadn't already done this, 720, which is the HOA statute, requires 100 more parcels shall also have a certain list of documents on the website or portal. So those are on the screen there, which is typical. I mean, the articles, of course, recorded bylaws in each amendment to that, the declaration of covenants in each amendment, the current rules. I mean, those things have, are usually readily available for most associations, but they've also added for HOAs must have a current list of all executed contracts. Just a list. You don't have to have all of the copies of the contracts, which I've run into a lot of people thinking that that's the case, but you just have to have a list of the current contracts and keep that up to date as you may change out. Your security company or your landscape company, you want to make sure that you keep that list updated. Also, a copy of the budget and any proposed budget that's going to be considered at the annual meeting. The financial report, any monthly income or expense statement to be considered at a meeting. Association's current insurance policies are to be posted. A certificate of each director who has attended the certification class for the state of Florida. All contracts or transactions between the association and any officer, etc., that may bring the association, board members into an agreement. So that is to be posted, and also any contract or document with a conflict of interest, which is leading, into that where that has to be disclosed to the members of the association. Also notice of any scheduled meetings of the members and the agenda for the meeting at least 14 days. Now that is been typical, but that is also a requirement now to post. And also you must post at least 7 days your post the application of any documents to be considered for voting at a meeting. So that would be a homeowner vote, not a board member vote, but that has to be, the document must be posted 7 days before. And also any notice of a board meeting, the agenda and any document for that meeting has to be posted. Where with the HOAs before, we didn't have to post agendas, but now that is a requirement as well for HOAs as it was for condos. Also, you want to make sure that inspection of and copying of records is done properly, and the statute is very clear on this. And owners may see certain information, they may request it. They are to be responded to. within 10 days. So you want to make sure that if you get a records request, that somebody is assigned that from your management company. Make sure that you are aware, the board is aware that this request has been made. And there's also penalties now for trying to evade that request or trying to not provide everything in the request and so forth. So you want to make sure that that records request is handled properly. And of course, Kirsten is on the call today, so there's always, your legal counsel to refer to if you have any questions or problems, and, they can advise you and certainly help you, in that process. So that's all that I have today on records. And on the screen there, it also, still has the list there if you want to take a picture of that or something so you can remember, what types of things you are going to be required to post starting January 1. So I would like to introduce the infamous master of electronic voting for Get Quorum, who you met at the beginning. His name is Frank Valdez. He is the life of the party, a lot of fun. We always enjoy, having Frank around. So take it from here, Frank.
Thank you, Diane. Can't thank you enough for that intro. Wow, certainly my pump it up girl over there. Appreciate it. So listen, folks. First and foremost, thank you, Diane, for that extremely informative. Those slides, right? Things are changing in Florida. For those folks on the call today, the reason you're probably on the call is there's a ton of changes going on. The legislation, as you can see, put together some really demands and said, hey, you've got to have this information now online, right? A ton of requirements for, as you see, documentation, websites, and we've got to get up to speed with all this. And certainly, again, that was Diane's portion. I'll get into electronic voting and virtual meetings, how that's affecting our communities today, right? And then, of course, when I'm done, I'll hand it off to, again, our legal expert, Kirsten here, which will walk you through the legal requirements for electronic voting and get into perhaps some Q&A. So don't forget, we do have a Q&A there. Post away, throw your questions in there, and we will be addressing them as we receive them if you'd like. And I know this one might be specific to what Diane just mentioned, so maybe I'll start here. It says, if the community has no website, it says if no website is the portal, okay, from a Lisa. Does that make sense, Diane? It says if no website is the portal, okay. I'm assuming the portal is the community website, but maybe I'm confused. Any insights on that?
It's the same thing. I mean, some people have a website and some people just have a portal where you can log in and get the documents. So as long as you have a way for your homeowners to register and log in and find the information that they need, you can have either. Just it's a preference for the association, whatever you prefer to have.
Perfect. So good first leadoff question there. Thank you, Lisa, for that. And again, folks, keep posting those questions in the Q&A. They're definitely, especially as in regards to electronic voting, want to see some material there. So let's dive right in, get right into the e-voting slides here and discuss a little bit about that. So since 2015, legislation's been adopted in the state of Florida allowing electronic voting to be used, right? Here's where we are almost 10 years later, as I'd like to kind of start these presentations. We've got about 32% of the communities have documentation. They're permitting electronic voting. And this is specific to Florida today, folks, right? Because e-voting is all throughout the US right now in different associations. But specifically in Florida, 2015 legislation's adopted. Kirsten's going to get into that when I wrap up my portion here. And again, here we are in 2024, almost 25, with 32% of the communities. Good start, right? Certainly COVID threw some fuel on that fire for us. As far as the condominiums, HOAs, and obviously the co-ops that are using this, not only 32% of them have that legislation in place or the rules in place now, but what we're finding is, excuse me, and what we're seeing is that participation rates jump from 20 to 80%. Huge participation rates with e-voting. Why? It's the likes of why we have massive participation rates on a webinar like today, right? North of 100 signed up. Versus perhaps, an in-person event where you've got to get in your car and may not drive with the schedule that you have. I feel like it almost lets you multitask. And it's the same goes for electronic voting, right? Whether it's an owner that is out of state, whether it's an owner that, quite honestly, these days is on a cruise ship, right? I've seen things like Norwegian Cruise Line having Starlink, or internet in their cruise ships these days. So you can literally be in the middle of the ocean casting your vote for your association these days, right? And electronic voting certainly allows for that to happen. So ton of participation. We'll jump right into the next slide here and just kind of dive into a little bit about electronic voting. So some of the takeaways I want everybody to have today is to understand the different types of e-voting, because I feel like when you say e-voting, it's kind of a general word being tossed around, especially in Florida these days. And then we'll get into why we should be using e-voting in our communities. So electronic voting. E-voting is, of course, e-voting by owners, right? Designated voters in communities that allows them to use an electronic means to cast an official binding vote for the association. Now, I want to make a clear distinction. What we're talking about today for e-voting, especially as it relates to the statutes, is not a survey, right? So those survey monkeys and survey softwares that you guys are using for your communities, generally those are non-binding votes, right? What we're discussing here is specific legislation that's allowing an official binding vote for an owner, deeded owner, to be cast. All right. So what types of electronic voting do we see out there, especially, again, specifically to the state of Florida? There's a few, believe it or not, there's quite a few here. We've got three, excuse me, three main ones. The first one would be what we call kind of an advanced electronic vote. And what's an advanced electronic vote? Most of our condos are 718s. Most of our co-ops out there 719s. And I would say current day, almost all of our 720s, our HOAs, are providing ballots to owners in advance of the day of a meeting, right? So whether it's that secret ballot for the annual meeting, again, 2 weeks or so, maybe 3 weeks before the day of the annual meeting, generally we call it an advanced electronic vote. It's an e-vote that goes out to these owners and allows them to cast a vote much in anticipation of even the date of the meeting. Why are they doing that? Number one, you're giving people a heads up, right? A little bit of a runway for reminder emails to be sent out and more participation. And, you know, quite honestly, as you can see there, it allows the owner to cast that vote from just about anywhere they have access to the internet and to their specific electronic ballot. So one type of e-vote that's being used out there. An e-proxy, right, or an electronic proxy is a type of electronic vote as well. And where do we use that? In what situation? Well, we've got a ton of our condominiums in Florida that are certainly working on things like material alteration votes, right? Special assessments, you name it. There's quite a few different roofing projects, anything that requires an owner to cast a vote, but isn't specifically a secret ballot vote, right? Is generally put on a limited, what we call limited proxy out there, all right? So an e-proxy vote, usually a limited proxy, can be used electronically these days as well. Unlike the, excuse me, unlike the advanced secret ballot, the electronic proxies are usually revocable. So keep that in mind, right? As you kind of discuss things like, hey, electronic limited proxy. Well, hold on, how is that different from a secret electronic ballot? The revocation features are a little bit different, but in the general, from an owner's perspective, they're receiving a voting form, they're filling that out, and they're returning it electronically without having to leave, right, their desk or wherever they're doing that from. All right, let's go to the real-time vote, that third type. So I still have a handful of HOAs, especially in the state of Florida, that have things like nominations from the floor for their annual meeting, right? And voting only the day of. And some of my 720s, if you're on this call today, and especially if you have older documents, certainly connect with your association council. We're seeing a massive trend and a big movement and push in our older HOAs into basically redoing those docs and making sure they have more of a condominium style procedure. Why? It really limits that chaos that you have. So think about it, right? 720, HOA, maybe 1,000 doors, maybe 500, and we've got upwards of 15,000 door communities, asking owners to all show up on one night, right? No casting votes in advance in that specific scenario, and nominations from the floor. You're going to need something called a real-time vote or electronic voting software to support that. Perhaps allowing owners to log in via webinar, right? Zoom webinar, and perhaps allowing those owners that have been vetted already and confirmed to vote real time in that Zoom webinar platform after nominations from the floor have been cast. So there is software supporting what we call real-time voting. Again, how much it is used, especially in our 718s and 719s, not much, if any at all. But certainly for our 720s, if you're in that situation and you think there's no way we can vote electronically because we don't send things in advance, have no fear. There is certainly electronic voting platforms, including a quorum that can support your community out there. I will tell you though, one final thought on the different types of votes. what we're seeing is a lot of the newer associations, whether it's Lennar, Pulte, all these new developers, new communities, making sure that their documents speak to more so of a 718 procedure, right? So it is more of a certainly a first notice with a notice of intent, and then a second advanced ballots. Even though the 720s are following the 718 procedures, probably for good reasons. It's a lot less chaotic the day of the meeting. Why use electronic voting? So these are the top reasons. I used to love the top 10 lists the comedians put out there. So it's not a top 10, but it's certainly a top 5 or 6 here. Many reasons why you should be using e-voting out in your community. I'll give you some of the top ones. Increased participation. For those folks on the call, maybe wondering why in heavens would we want people to participate? Well, listen, you're all going to come at a crossroad where you've got some sort of amendment that's got to be taken care of in your community, right? Perhaps a material alteration vote out there, perhaps some sort of declaration amendment, which I certainly know Kirsten will speak to in just a bit. And at that point, in order to get that participation, you're going to need an electronic voting software to assist you. So that increased participation, which generally looks like 70% of the owners opting in year one to e-voting, is extremely valuable in the scenarios where certainly you need that vote. Reduce printing and mailing costs. So generally speaking, electronic voting pays for itself out there. It's budget neutral. How and why? By reducing the amount of printing of notices and mailing that goes out to the owners that are opted into e-voting and opted into electronic notices. You can obviously provide them an electronic version of these docs. Improved efficiency, ton of efficiency behind e-voting, ton of tracking, reporting, and capability, believe it or not. Auditability certainly increases with electronic voting. There's footprints, what we call digital footprints, in every single step of this process. As far as transparency, certainly I can tell you from an e-voting standard, the day a notice goes out, it's logged. The day a notice is opened, that is logged. The day that notice is delivered to the owners, it's logged. There's a ton of steps here that are certainly followed and documented along the way, including the final results. As far as security, which is always a hot topic for e-voting, believe it or not, this is a much more enhanced version of security over paper traditional voting, right? Think about that paper traditional voting. It's going to mailbox to the owner. We're hoping that snail mail got it to them. The mailbox is being opened, they're filling out the documents and returning it back. Very little of any tracking whatsoever along the way here, right? On the electronic voting side, from the security perspective, you're going to have not only a ton of tracking, but we're going to have authentication methods, right? Encryption, authentication that's going to ensure the validity of that vote. And I'll take it one step further, one last thought on security. Every single voter that casts a vote on an electronic voting software in the state of Florida will receive an electronic receipt, right? So just want to be very clear that we do have what we call an electronic receipt after a vote has been cast. So that is something that certainly an owner can expect in their experience in an electronic voting platform. We'll go to the next slide here. All right. Virtual meetings. So we talked a little bit about e-voting, got everybody familiar with the different types of e-voting. And I just kind of want to spend a minute or two here on virtual meetings. I feel like we're all certainly familiar with things like Zoom these days, right? Like the massive virtual technology that's being used out there. Well, believe it or not, there are different types of virtual meetings that are being leveraged, especially post-pandemic. I think in the general, we started with just kind of what we call Zoom meetings, right? Or WebEx or Microsoft Teams. And then we're certainly spinning that off into what we call hybrid meetings for these associations, right? So virtual meetings, what are they? Meetings that allow members to attend just as we are today, a meeting, but all virtually logged in. As far as the different types, there's a full virtual. I don't see a ton of those in Florida these days. I do believe legislation will eventually catch up and allow some of these communities to offer only a full virtual meeting. As of right now, today, I think about 99% of them are hybrid. So there's a virtual meeting option for your annual meeting or for your board meetings in conjunction with an in-person option. I call that kind of the transitionary state, right? Before one day, not too far in the distance, we will potentially have an option for full virtual meetings. But certainly it's a transition from all in-person to hybrid and then to, again, one day full. Hybrid meetings are allowing owners to log in from their second homes, from another state, another country perhaps, and still participate in all of their communities' meetings, especially the annual meetings and the special meetings. All right, why are they important, right? Why do we want to use those? Well, there's certainly many reasons. Again, we're going to go back to owner participation, right? Improved accessibility is, again, not a bad thing. Reduction in overall costs. Having these meetings, I've seen them, I've been part of them in hotel ballrooms, right? Cookies, coffee, you name it, all there. While that's good, perhaps a reduction in either the size of the ballroom or being able to use a smaller room in a community center in conjunction with a virtual option would certainly reduce the overall cost for the community. More control over the audience. Certainly it's nicer in a format like what we have today, where if an owner by mistake, and I've been part of this, is mowing their lawn or doing something to making a ton of noise, they can be muted, right, or unmuted in the meeting. So in terms of what I want to point to here is also meeting attendance, very easy to take with a virtual meeting platform, but you've got to make sure you're using a webinar meeting platform like the one we're using today, Zoom webinar, versus Zoom meetings, right? Zoom meetings is that one, the kind of the general invitation to everyone. You're not really sure who's using it. You could get a Miami 305 or Kitty Cat 2000 logged in to that Zoom meeting. I've seen those. Where you're using webinar technology, no matter what provider is using those, there's certainly usually a one invitation per person policy. And again, meeting attendance can be taken as well. So ton of other features here, automation, right? Meeting efficiency, 100% much more efficient, shorter meeting times. Reporting, you can report not only the virtual attendance, but again, some of these other features that the platforms allow for. And improve transparency. Again, here you go. You, as a community, you've got owners saying, hey, I get out of work at 5 o'clock. I can't be at the clubhouse at 5 p.m. Perhaps they can log in and listen into the meeting, or it can be recorded if you wish to do so, and made accessible, to Diane's point, in the websites of the association. So some of those options for you there. We'll go to the next slide. I think we might be certainly wrapped up there. So on my end, that's what I've got. No, not to worry. I see some Q&A on the chat here. We'll walk through that, but I want to make sure first give some time to Kirsten Henza there to walk through the Florida voting statutes, make sure that you have an understanding of how they say that this has to be implemented and some of the document amendments, and then we'll dive right back into some of the Q&A. All right, take it away, Kirsten.
Awesome, great, Frank. Next slide, please. Okay, well, just a fun slide. Healthcare alert: owning a home in an HOA may be hazardous to your health. Hopefully not. So let's move on to the next slide. All right, so Frank just talked about the benefits of instituting electronic voting. So I just want to talk for a minute or two as to what really is the process, because I think there's a lot of misconception of what is really required to institute electronic voting, and it's really rather simple. I call it basically requiring two-step process. And the first process really is the board has to formally adopt e-voting for their community. So that is done typically at a board meeting. And to notice that board meeting, you have to provide notice of the meeting at least 14 days prior. So you either mail out the notice, or you hand deliver the notice, or you can electronically transmit it, email or fax, to any owner who has consented to receiving notices electronically. And there's a resolution that the board adopts, and certainly we as a firm have assisted many clients with the drafting of that resolution and the notice meetings that you need to get you to e-voting. But there are platforms, and I believe Get Quorum is one of those, where they can actually assist you with the paperwork you need to institute it. So there's no right or wrong answer. You can either get legal guidance or, get Quorum on how to get you the paperwork to get the resolution adopted. And then once the board formally approves e-voting for the community, the owners still have to opt in. And that's the second part. So while there's no membership approval requirement, the owners are not required to formally approve the process, right? It's still a board decision, but owners have to opt into the system if they want to be able to e-vote, right? So there are certain consent forms that you have to provide to the membership to have them sign off if they want to participate through e-voting, right? So once the owner opts into e-voting, they can vote electronically on really any issue that goes before the membership, okay? Unless and until the owner decides to opt out. So it's really up to the owner, okay? Now, for those owners who choose not to opt in and vote electronically, they would still have to vote, the old-fashioned way. So either at a membership meeting in person or through a limited proxy that gets mailed to the owner in advance. All right. Now, the statute says that electronic votes are only limited to the specific issue that's presented to the owners. Okay, so if at issue is a material alteration vote, that is the one and only thing they can vote on. Okay, which is not that different from having owners vote, by limited proxy or ballot at a meeting, right? You can only vote on the specific issue that's on the ballot or limited proxy. And then the other beautiful thing about electronic voting is that e-votes count towards quorum. So the statute already says that if you cast a vote electronically, that vote also counts towards quorum. So you don't have to then have the owner physically appear at the meeting to have a quorum in order to proceed with a membership meeting, right? So the e-voting already takes care of that. Now, the statute does provide basically a laundry list of the requirements that the e-voting platform has to meet in order to qualify, right? So I've identified a few here. For example, the association has to be able to authenticate the member's identity. The transmission of an electronic ballot must be secure, right? And has to ensure the secrecy and the integrity of the ballot. And then the association must provide a method to confirm at least 14 days before the voting deadline that the member's electronic device can successfully communicate with the online voting system. And certainly platforms like Get Quorum will, not only do they meet all the requirements, but they will assist you to make sure that you comply with whatever requirements you need to make sure that the platform works and it's ready to go. And can do what it's supposed to do on the date of the meeting. All right, so those are the statutory requirements for instituting e-voting. But let's talk about one aspect that you can use e-voting, and that is to amend your governing documents. So next slide. So e-voting, again, can be used really for any action that requires membership approval, right? So let's not get that confused with board action. So typically the board is the one that votes and approves resolutions as to maintenance and operation of the association and the community. But there are certain issues upon which the owners get to vote, right? So we're talking about e-voting for issues that owners get to vote. One of them would be to amend your governing documents, right? And I just want to highlight some misconceptions, right? Provisions in your governing documents that you think are protecting the interests of the association when in fact they are not, right? And especially if you have some of the older documents, perhaps drafted in the 60s and the 70s, you might benefit from just an overhaul of your governing documents. So getting with legal counsel, reviewing them, and then updating them. All right, so one of the misconceptions, and again, these are just 4 of the more common. Of course, you might have issues that are particular to your community that you might be looking to amend, right? And if so, I can tell you from experience that instituting e-voting, particularly for amending governing documents, it is so helpful to get the vote that you need. All right, so the first misconception is a foreclosing lender is required to pay 1% of the original mortgage debt or 12 months of delinquent assessments. Is that true or false? Well, it's true in that this is what is referred to as the safe harbor, right? And both 718 and 720 provide that if you're a mortgagee and you take title to a unit or a lot, then that mortgagee has to pay either 1% of the original mortgage date or 12 months of delinquent assessments, whichever is less. But is that guaranteed? And the answer is no. That amount is not guaranteed just because it's in the statute. You have to take a look at your governing documents and see what provisions, if anything, there are for mortgagees' liability to the association when they take title. Now, some of the older documents might have a provision that says that if a mortgagee takes title, they owe nothing to the association, right? Or you might even have a clause that says that a third-party purchaser that takes title at a mortgagee's foreclosure sale owes nothing to the association, right? Well, if that's the case, then that provision has been used by mortgagees in courts, and courts have validated those clauses, which means that courts have then ruled in favor of these mortgagees and have held that these mortgagees owe none of the delinquent assessments to the association that accrued prior to that mortgagee taking title. So you might be one of those associations that are not protected at the moment, okay? So take a look at your documents, see if you have such a clause, and then discuss with legal counsel your options of amending it. The big caveat about this type of provision is that your documents might actually require you to get mortgagee's consent in order to amend that provision out. Now, both 718 and 720 do outline a statutory process by which that you have to follow in order to get mortgagee consent. And it's not a difficult process. There's just a few steps that you need to go through. You'll need to do a limited title search on each lot to confirm the mortgagees, right? Then you have to let the mortgagees know you're amending this provision. And then you use a negative notice letter, basically saying, hey, mortgagee, we're amending this provision, okay? If you have any objections, let us know. Otherwise, if we don't hear from you within 60 days, your consent is presumed. And I can tell you my experience, rarely do mortgagees respond to these types of letters, right? So once the 60 days have gone, you can go ahead and report the amendment in the public records, provided the owners have duly approved that amendment. So just want you to be aware of this one, because this one, could affect your ability to collect assessments, right? And nobody wants to be in the negative. All right, let's move on to another very common misconception. And that is all new owners and tenants must go through the screening process in the community. And the screening process refers to a buyer or tenant that wants to live in your community, and they have to submit an application, do a background check, pay an application fee, and then the board determines whether or not to approve that applicant in the community, okay? Well, the statute, neither 718 or 720 really address this particular issue, right? So it becomes then an issue that is governed by your governing documents. So you have to look at the governing documents, and specifically your declaration of condominium or declaration of covenants, if you're in an HOA, to see what authority, if any, the board has to approve or disapprove these types of applicants. If you don't have documentary authority in your actual governing documents to screen these applicants, then you're potentially subjecting your association to a successful claim, especially when you disapprove an applicant, right? Now, I have come across communities where boards have adopted policies allowing boards to approve, disapprove these types of applicants. That is not enough. It's not enough to adopt this as a policy or rule. This type of particular, I guess, prerequisite to residing in a community has to specifically be set forth in your declaration to be enforceable. Specifically when it comes to purchases. And the reason is because with purchases, you might have heard of the term right of first refusal. Well, in Florida, and this is law that's been developed through case law. So law that's been developed by judges, not by statute, not by legislatures. But Florida case law says that if you're an association that wants to approve or disapprove buyers in your community, you also have to have a corresponding obligation to exercise a right of first refusal, and then provide an alternate purchaser if you disapprove the buyer for reasons other than good cause, right? And so that language has to be in your declaration in order for your approval disapproval authority to be valid under the law. Okay. All right. And again, you know, we talked about purchasers, but you might want to be able to screen tenants. You might want to be able to screen other types of individuals. What about if an owner, you know, conveys title to, you know, to a sibling or to a parent, right? After the owner was initially approved. Well, that's not a traditional sale. That's more of a gift conveyance. Are you a community that wants to be able to screen those types of transactions? Or what about individuals that move into the unit after the owner or the tenant have been approved? For example, you know, additional occupants, additional family members. If so, again, look at the authority that you have in the documents. And if you don't have sufficient authority to give you what you need to screen these individuals, then you might be looking to amend. All right, another misconception. Once the law changes, the change is automatically applicable to the community. So let's take a recent example, right? A number of laws went into effect July 1st of this year. One of them, for example, for HOAs, there's a law that says that associations cannot prohibit commercial vehicles or work vehicles to park in the owner's driveway. Well, does that change in the statute apply to your community? That type of change is what is known as a substantive change, right? It affects the vested rights of owners. And the only way that that type of change would apply to your community is if your documents have what is known as Kaufman language. Now, Kaufman refers to the magical words "as amended" from time to time that you might see at the end of reference to either 718 or 720 in your declaration. So you typically, the first page of the declaration will have a statement to the effect of that, you know, this community has been developed and is subject to 718 or 720 as amended from time to time. Now, if you have those words, what that means is that any changes to the statute that the legislature passes will retroactively apply to your community without having to amend your document. Substantive changes, right? Then there's changes that are procedural, right? And they affect more of procedure of how the community or association operates. A very common typical procedural change would be a change to the election procedure, right? So every time the legislator changes anything about condominium elections, that's a procedural change, and it will apply to your community regardless of whether or not you have Kaufman language, right? So you don't have to amend to add Kaufman in order for you to have to follow 718 to conduct your condominium elections, because it'll just apply. And so the bottom line here, the big takeaway here is legislature will pass laws. Some might be good and to the benefit of the association, and some might not. And I'm talking specifically about substantive changes. So whether or not you as a board, as a community, want substantive changes to the statute to apply retroactively, that's a decision you have to discuss with your legal counsel, and whether or not you might want to amend what to either add Kaufman or remove Kaufman from your documents, right? All right, and then the last misconception: if a pipe in a wall only provides service to one unit, that unit owner is responsible for maintenance. Well, while that might seem logical, that might not necessarily be true for your community, right? So you have to look at the governing documents. You have to look at the declaration specifically in the maintenance section to see what are the maintenance obligations of the owners and what are the maintenance obligations of the association, because that is the document that will dictate dictate that, not the statute, right? Your declaration. So you might have a provision that in fact says this, right? That if there's a pipe in a wall, even if it's a common element pipe and it provides services only to a particular unit, that owner is responsible for repairing and replacing it, right? But the opposite could also be true. So it really will depend on your declaration. So take a look at your maintenance provisions if you haven't reviewed those in a while. And, confirm, do they accurately reflect how you currently maintain and operate, the common elements or portions of the unit? And if not, then you might benefit from an amendment to your documents to accurately reflect the maintenance obligations. All right, so again, these are just some of the more common misconceptions. You might have other issues in your community that you might be looking to amend, but certainly encourage you to consider e-voting, setting that system up before you propose the more substantive amendment changes to the owners for approval. I think you'll definitely see that your success rate will be increased through e-voting. All right, that's all I have.
Well, folks, Kirsten, can't thank you enough. That was amazing. A ton of great information there. Listen, for all those on the call today, we do have some Q&A. We're going to try to tackle some of these questions and kind of hand them over to each expert on this panel. So thank you first and foremost for putting those in the Q&A chat. But before I forget, I want to thank our expert panel here today as we take these questions for everyone. And again, advise everyone that, look, everything that we're discussing today should be done with your association counsel and your property management provider, right? Along with an electronic voting provider. If you're trying to establish these processes and procedures, get everyone involved in your community is the best advice we can give you. It's certainly, if you need any of our information, it's there, it's in front of your screen. We will make ourselves available to you even beyond the call today. So please screenshot it, take a picture with your phone, whatever's easiest. As far as the question on the presentation, yes, our expectation is to send you a copy of this recording and this presentation if you're on the call today. So I'll dive into some questions here. And we start with the first one. Can an HOA board only allow board members to use Zoom to attend meetings? The board hold their meetings at the clubhouse where members can attend, but some members are snowbirds and cannot attend in person. So Bonnie, thank you first and foremost for that question. And here's what I'm interpreting is, can an HOA board only allow board members to use Zoom to attend meetings? Generally speaking, when an association uses Zoom, right, and they have a board meeting per se, especially in a 720 spectrum, it's usually the Zoom link is circulated around to the general ownership, right? That's the idea of a Zoom meeting. And usually board meetings need to be open to the public. I'll certainly let Kirsten chime in on that. But usually board members should be attending, whether it's by Zoom or in person, that specific board meeting. If it is a fully only Zoom meeting, I certainly would anticipate that owners would also be able or allowed to attend. I do not know of a policy where an HOA can hold a board meeting via Zoom for only board members. No one else can attend and then shut the meeting down afterwards. Kirsten, any thoughts on this?
I mean, only allow, right? That's
Right.
that's a big word. So I would say no.
Right. Same thing
It's
here,
certainly
right?
an
Only allow board
option,
members. No, it should be open
Yeah.
to the public. That Zoom link as
Yeah.
well. All right, I've got another one here. From Robert, thank you again. Can you provide guidance as to how a condo association would implement an electronic voting option? So hopefully we've walked through that with you. Certainly feel free to connect, whether it's with myself, information's there, Robert or Kirsten. It's implemented through what Kirsten was just showing you. It's a 14-day notice to the membership, right? And it's also a really compliancy as far as getting owners opted in. So you've got to get a consent form in front of owners to opt into electronic voting. So again, happy to walk you through those steps more granularly. You connect with us if the presentation didn't do it for you. Does the statute allow for virtual meeting? From Kent, thank you, Kent. Does the statute allow for virtual meetings? So obviously, you don't know which specific statute you're referring to there, but do statutes allow for virtual meetings? Kirsten, any language that you've seen there that allows?
Yeah, I mean, chapter 617 of the Florida statute, which is the statute that governs non-for-profit corporations. And associations are not-for-profit corporations, so they are still governed under chapter 617. They do authorize virtual meetings, and to some degree, 718 and 720 touch on that. What they don't expressly allow is for meetings to be conducted 100% virtually, right? As Frank had mentioned, so that the statutes have not yet caught up with how some associations might want to operate. Okay.
Thank you. Jeff, again, thank you for that question. Can a condo committee request documents? Well, again, a little bit of a general question, but my interpretation is if you're a committee member, which usually means you're some sort of an owner in a community, can you request documents? And again, it's kind of an open-ended question. So a records request allows owners, members to request official records from the association. And usually that is the avenue or the vehicle that you should be using if you're looking for any types of official records of the association. So I'll hand it over to Kirsten if she has anything to add, but that's pretty straightforward stuff for just about every owner.
I agree.
All right, so we've got from Lisa, does the 14 days need to be mailed? So I guess she's speaking to the consent here from the owner, or can it be e-blasted and posted? So I'll walk you through this, and again, I'll let Kirsten chime in if I'm missing something, but the 14-day notice where you're letting owners know the board will be voting on a resolution to allow electronic voting. Generally speaking, if an association already has established what we call electronic notices for owners, right? If they've got a consent on file for an owner that has previous to that 14-day notice being sent out, has opted into electronic notices in the community, you might have a great reason why that 14-day notice can be emailed, I should say, to that specific owner in lieu of a mailer. Now, if you do not have, if you're an association on this call today, you do not have a specific consent from owners allowing that owner to receive what we call electronic notices in that community in lieu of a paper-based notice, you're probably going to have to get them an official paper notice, letting them know you've got a 14-day notice going out, whereby the board is going to be voting on adopting a resolution to allow electronic voting. Did I miss anything there, Kirsten? Or?
That's good.
All right, awesome. All right, John, and thank you, Lisa, for that. John, can an electronic vote be extracted in the event that the owner sells their unit prior to the election? A new owner's unit is blocked from voting. Great question, John. Thank you, and certainly a pleasure to see you on today's call. I know you certainly participate in a lot of these, so thank you for joining us. E-votes, if you're working with a platform out there, folks, that does not allow a vote to be extracted, even a secret ballot vote, please buyer beware. There are a lot of cases where an owner may have casted an electronic secret vote, sold their unit prior to what we would call an annual meeting, right? And then by definition, that vote generally should not be counted towards the final count if they've sold that unit and vacated that unit and are no longer an owner prior to the date of that said meeting, right? And so you've got to have an avenue for that and a vehicle for that, and certainly connect with your electronic voting providers out there and ensure that they're able to assist and support. In our expertise, usually that vote is not only extracted, but what we try to do is get the new owner of that unit to sign up for electronic voting and cast an electronic vote, one vote per unit. Did I miss anything there, Kirsten? Because it says a new unit is basically, a unit was sold and a vote was cast prior to the day of the meeting.
No, I mean, essentially the new owner is just going to have to consent to e-voting. Yeah.
Or cast a paper-based vote, one or two. Right?
Yeah.
If they haven't opted in.
Yeah.
All right. Would we possibly get an electronic copy of slides? Yes, we're gonna post them over there. All right, maybe Diane, I've got one for you. All right, don't go away, Diane, don't go away. I've got one for you. How long does the association retain voting records? I know we were speaking to records earlier, and I definitely feel like probably all of us out here can answer that. But voting records, how long does the association retain those?
Usually 1 year from the annual meeting, one annual meeting to the next annual meeting. Person, do you have anything to add to that?
Yeah, I mean, if the voting records refer to the, the membership vote that was taken on a particular issue, then that's correct. Usually 1 year from the date of that vote.
Perfect.
I mean, electronic voting is the same, so I don't know if they were asking specifically about electronic
When
voting.
it comes to e-voting, we're going to refer back to the statutes for the minimum amount of time that we have these records. Generally speaking, we've got these records much beyond the date of limitations from the state, right? We keep these in what we call the cloud, and it's stored as data here securely in the servers, and that information is generally available much beyond. From anonymous there, can a member request voting records to view how others voted? Well, if you're referring to how others voted for a secret ballot, no, you're not going to get the information of how a member voted in a secret ballot situation. Can you request voting records in the general, like voting records? Sure, records requests for your association, right? On the final results, I guess you can call it. And then specifically when it pertains to something like a limited proxy, right? We've got an amendment, it's a yes or no vote. In many of those cases, it's not a secret ballot, right? So you can specifically request to see, hey, did a member vote yes or no on that amendment? Generally speaking, that's a transparent vote for that association. So can you request again how a member voted? Secret ballot, probably no. Just about every other vote, you may be able to see that information. So thank you for that, Mitch. As we wind down here to the last few, if an HOA member owns a rental and voted to amend a declaration to restrict a 30-day rental to a 90-day rental, has this member waived the right to be grandfathered in? Maybe I'll let Kirsten decide whether we're going to take that one or not.
So I guess they're increasing the rental period
Correct.
from a 30-day rental to a 90-day rental.
Correct.
Well, typically what the HOA statute was amended in, I think, 2021 to basically say any amendment that restricts or limits the term of a lease or how often you can lease, or prohibits leasing, would only apply to owners who voted in favor of it and those who take title after the effective date of the amendment. Seems like with this type of amendment, you're not so much restricting, you're actually making it, you're increasing the term of the lease. So I don't know if it would apply in this particular case.
Okay. We'll leave it there.
Yeah.
Kim, thank you for that. Our proxy is valid for 90 days from the date of the meeting, from the date they were submitted. I believe it's the day of the official meeting. I will again let Kirsten speak to that when it comes to proxies and whether they're valid beyond the date of the meeting.
Their proxies are good for 90 days from the date of the original meeting date.
Correct. There you go. So that's yes. And then as far as Kim, thank you for that. How do you reopen a vote that has been continued because it didn't pass? So in our electronic voting world, Kim, we have a way of allowing an owner to go back to the original link if it's a something like a limited proxy, and they can basically revoke and resubmit that vote. If not, that vote counts. If it's open and continues to be open for 90 days, the vote continues to be counted if they casted an original vote per se. So yes, perfect. All right, Christopher Mackey, we're looking at software to support our committee processes, tools for collaboration. You're wondering if these tools support archiving policies. Are there any other legal concerns that we should be aware of? Does it matter where we invite the PM staff into the workspaces? So these workspaces are very obviously conducive and collaborative, Chris, to having property management staff understand what it has, what it says, what it contains. These records for an association usually are used by management. So we've got from Shirley Land, if a resident requests a hard copy of the governing documents, they are posted on the website, do we have to send to them if they request a hard copy, Kirsten? It's a good one.
I'm sorry, where are you?
So I've got a Sherry Land Gabrielle. If a resident requests a hard copy of the governing documents but are posted on the website, does the association have to send it to them?
Well, if you're in a condominium association, the statute even says that you can refer them to the website if the document that they're seeking to inspect is posted. So in the condominium setting, you can do that. In the HOA setting, in an abundance of caution, I would send them a copy.
There you go. And got just last two here, which is Sue, can the meeting for approval of electronic voting be done with another meeting that requires 14-day notice? Person?
Yeah, I mean, you can just have multiple agenda items on the same notice. If you want to do that, that's totally acceptable. Just make sure you clearly identify all the agenda items to be discussed.
Perfect. So just make sure it's on the agenda, folks. I think that's the big takeaway. And here we've got, how do I see? Okay, how do I see who the named proxy is for a homeowner? Kim, on the electronic voting platform, the administrator would have access to who the named proxy holder is for a specific homeowner. So if a homeowner has named a proxy holder for any limited proxies or general proxies, that information would reflect in what we call an administrative dashboard for electronic voting. So there is a reporting feature that gives you that information. We call it the dash in our world. Let's see, can we send and receive proxies in DocuSign, or is that considered electronic voting? I'll let Kirsten speak to this one, because I've heard a lot of DocuSigns in my almost 4 years here with Get Quorum, and folks saying, oh, we don't need electronic voting, we just use DocuSign, and we have our own kind of sort of back gray area spin-off of e-voting. So I'll let you kind of handle whether DocuSign is an official electronic vote for an association, Kirsten.
I mean, I'm not aware of any law that necessarily prohibits someone from docu-signing a limited proxy. Right, that's still not considered an electronic vote. That's just you signing. It's the equivalent of you signing a proxy and then emailing it to your property manager, right? It's not an e-vote. You still have to go through the formal steps of noticing your membership meeting, mailing out the notices, mailing out the proxy. So it's definitely not intended to be in lieu of e-voting. There's definitely way more benefits of doing e-voting, as Frank had discussed earlier.
Yeah, definitely. And the only thing I would add to that, Kirsten, is that if you look at the electronic voting statutes, it's very specific in terms of what the platforms need to provide an owner. So I would just refer all the folks on the call to what Kirsten had up earlier, the 7, 18, 19, and 20 e-voting statutes, because there is authentication steps that have to be taken by an electronic voting provider, and there's a few different steps, right? So there's a ton of security and authentication that goes behind an e-voting platform, and trying to, I guess, kind of interchange it for just a DocuSign. If that's the goal, probably not sufficient. If you're asking an owner to sign some sort of binding document electronically, then DocuSign will probably do. Last one here, I think I've got, if an owner signed up for electronic notices, does the budget still have to be sent out as a hard copy? So my reference to that would be no. If an owner opted into electronic notices and has a consent on file for e-notices, and you've got the annual budget to be sent out, I do believe, in my interpretation, that it can be sent out electronically, so long as you have some sort of official way of tracking that notice was sent and delivered to the owner. I'll let Diane and Kirsten chime in if you feel differently about a budgets being sent electronically to an owner that has previously consented to e-notices in the community.
Yeah, I agree. As long as the owner has consented in writing to receiving official notices by email, then yes, you can email the notice along with a copy of the budget.
Perfect. Thank you. So we're going to leave it there. We appreciate you guys hanging in with us just a few minutes over. Give you back the rest of your afternoon here. Look, on behalf of Get Quorum, electronic voting provider here in the state of Florida, obviously Kirsten Hensey, our legal expert here today, and Diane Skinner, Director of Community Management for Artemis. We want to thank you for joining us today. This recording will be available. We will send it out. And again, our information is here in front of you. Do not be afraid to follow up with us. But wishing everyone a happy Tuesday afternoon. And a happy November as we roll around very quickly here to Thanksgiving. So have a great week, folks.
Thanks, everyone.
Thank you.
Bye-bye.
Bye.